for a lot of agents and folks. So, how many of you currently understand or have read the section within the purchase agreement about your EMD?
No.
Yeah. And what's fascinating is that every single purchase agreement has somewhat similar and not so similar language for an EMD. So just because you practice in one area under your association, they might practice slightly different. But the important thing is when it comes to earnest money deposits, you really need to be explaining what this process is to your client. What are the risks associated with the EMD? And we're going to get into this a little more in depth. But with any earnest money deposit, the number one thing that we should always be letting our clients know is that you don't automatically get your EMD back. How many of you have ever
Oh,
had a conversation where your client, you say, hey, don't worry, your EMD, you can get it back if you terminate? How many? Did we always say that? Do we even mention anything about the EMD? There is never going to be a guarantee where the client will get the EMD back, ever. Even if you have a lawful termination, your client does not automatically get their EMD back. Does that blow anyone's mind?
no.
Okay. The contract says that they get it back, but they still don't get it back if the seller disputes it. But we're going to get into that. But I think what's the most important thing when we start dealing with earnest money deposits is really sitting down and having a conversation with your client about what the requirements are, and that you're discussing that EMD, that you need to collect it very quickly upon the execution of a purchase agreement. Now, I love asking this question. How many of you actually get a check in advance and hang on to an EMD? Anyone?
No. No, I've
Don't,
never done that.
don't do it. We're not allowed to hold EMD monies. So the best practice is you need to wait until the actual contract is executed by both buyer and seller. And then you have a timeline that you must perform by, meaning you need to get the EMD check written based on how much is written in your purchase agreement. Now you might say, well, who's going to be holding this EMD? Who do they write the check out to? How many of you use Five Star? Anyone use Five Star as the brokerage to hold the EMD?
Yes.
Okay, that's one option. You can also have a title company hold an EMD, right? If you're working in Florida, you'll probably have an attorney holding the earnest money deposit. So they do things differently in Florida versus how we do things in Michigan. So it's important to understand what's written in that purchase agreement and who you're going to give it to. Now, we might say that there is an advantage to having the broker hold it. You represent a buyer, you're saying, okay, Five Star Real Estate's going to hold the EMD. There might be an advantage to that. And people will say, well, what's that advantage? It's a very slim advantage. Some associations allow Five Star as a broker when we are holding an EMD to send out what's known as a 15-day letter if there's a dispute where we can say, hey, look, it used to be 15-day or 30-day, but there is a nuclear option that Five Star can use only in certain associations. I know Garrar currently allows us to do this. G-Car does not in Grand Rapids. I don't believe Lansing does. Doug does. West Michigan does the great, where you practice Wimlar, do they allow a 15-day? No. So this, if you're a Garrar agent, it might be there could be an option to help you slightly. But what this letter does is that when there's a dispute, it allows us to say, hey, look, seller, we understand that there's a dispute. If you don't respond to us within 15 days, we are going to provide this EMD to the buyer. That's the only time a neutral party can actually do something. You have to understand when someone holds that EMD, whether it's an attorney, a title company, or Five Star, we have to remain a neutral party by law. So there are escrow laws that a broker must follow or a title company must follow anytime they hold earnest money deposits or checks or whatever. They do not have a say in how that money gets distributed back to the parties. Only the parties do in a written form. So just be mindful that when you're writing something in your purchase agreement, that you do have an understanding who your preferred escrow or whoever's going to be holding those funds will be, whether it's Five Star Real Estate or a title company or an attorney. And you have to understand that once that buyer and seller sign, you're under an extreme time is of the essence deadline to collect the EMD and turn it over to whoever is whoever you're going to be holding whoever's going to be holding those funds. And you might say, well, how much time do I have once a contract is executed to get those funds? And I would have to say, what does your purchase agreement state? In Garar, it says that earnest money deposits shall be submitted to a broker or title company within 72 hours of the effective date of the agreement. Some will say within 2 business days. Some may say 48 hours that you have to get that check to Five Star or to the title company. Now, once they get that neutral party or the broker or the title company will have 2 business days to deposit it into their escrow account. So they
Hey,
do have guidelines and timelines.
Eric, before we leave the 15-day letter issue, are we going
Yes.
to come back to that or um, I
What's your thought?
well, one of the concerns I have is the 15-day letter is not actually endorsed by the association. It's used as common practice between the brokers. The danger in that is, let's pretend, for example, you have a 10,000 or 15 or $20,000 earnest deposit. Uh, the 15-day letter is not going to um, alleviate the responsibility and liability of the person who's holding the escrow. For example, Five Star, if we're holding the escrow and we send out a 15-day letter and we get no um, objection to that, no challenge against that from the buyer or from the seller, then we release that 15, 10, $15,000, whatever it is. That doesn't mean Five Star's still not on the hook for that escrow if later there's a challenge. That's the caveat here is that it's not a legally enforceable document. It becomes a question of how much risk does the broker who's holding the escrow want to take on in releasing that money to a buyer or to a seller in either case.
Yeah, and the answer is that Five Star doesn't want to take on that risk. Rarely do we use that nuclear option. But
Exactly.
I bring that up because people will say, well, I heard something that the broker can do to help us. Well, it's only in a small geographic area and it's rarely used because ultimately Five Star would still be responsible for that EMD if it was inadvertently dispersed back to a buyer and we end up being held liable for it if the parties end up having to go to small claims or they hired an attorney.
And if the title company, if a title company is holding that escrow, the 15-day letter is not an option. They won't do it.
Correct. Yeah, because the title company will be following escrow laws, which are very, very strict, and you need to have both parties agree to the release of it. Now, one of the questions that we get often is, well, how do I collect that EMD? What can my client give me? My client wants to bring cash to me. Anyone ever see that? Cash, a lot of cash. You're like, no, no, we can't do that. Personal check, certified check, So we can have a personal check made out to Five Star Real Estate or a title company. We can have a certified check made out to Five Star Real Estate or a title company. Or they can use an online app. Anyone use the Earnest app? It's an online app that the client can go into and deposit funds. There is a surcharge for that, a slight fee for them to use that, but that is an option. Uh, but how many of you ever get someone's check, you deposit it with the broker or you deposit it with the title company, and then go back and verify that the funds have cleared? Anyone? Yeah, we should be doing that. We should be verifying that those funds have been cleared and that it didn't bounce. If we do ever get funds that bounce, and you're representing a client, your buyer, you are required to disclose to the other side that there's an issue with that EMD. You also you're supposed to disclose when you don't collect an EMD or your client didn't turn one in. Now, why is that? Why do we need to disclose that? Some of you are going to say, well, wait a minute, that goes against my fiduciary responsibility to protect my client. I don't want to tell the other side that, oops, they bounced a check, or oops, I didn't collect that EMD. Well, guess what? That's an occupational code regulation that we must follow.
It's
We
also
must
a code of
disclose,
ethics requirement.
and a code of ethics. Was that Article 1, not acting honestly with the public? And I'm
Correct.
sure there's a couple others that we can find.
Yes.
So disclosure is very important when that EMD isn't deposited properly and collected. Now, I see quite often in practice a seller or a listing agent will say, "Well, I want a copy of your check, the EMD." Is that required by law? If a listing agent comes to you and says, "I need a copy of your EMD check," no, there's no requirement that you need to provide that. There's nothing in there that states that you need to give a copy of a check or an EMD to the listing side. Now, does it help with transparency? Does it help with providing trust within a relationship of negotiations? Definitely. Now, if you're going to do a copy of that check, make a photocopy of it, black out the checking account numbers. Be smart about this. You don't want to just give someone's routing number or checking account number. You black it out. If that would satisfy things, if that makes someone feel good, then what's wrong with that? I'd say go for it. But there is no requirement by law that requires you to do so.
Eric, if a selling
If
listing agent asks for verification that the EMD has been deposited into the broker's account or with a title company, and the buyer doesn't want to provide a check, doesn't want them to see a check, what other options are to verify that it's been collected and deposited and cleared?
Yeah, so one, you call up the title company, call up the broker. Hey, have these funds cleared? If you need proof, they'll send you an email proof that yes, these funds have been cleared, and then you can provide that to a listing agent. Or a lot of times, if it's a title company, that listing agent will probably have to call and verify if those funds cleared. Or you can do that as a courtesy because it's your client. You might want to call the title company and say, "Hey, do these funds cleared?" Great. Hey, by the way, listing agent, funds have cleared. Just want to let you know.
In most cases, your buyer is not going to object to sending a check as long as the account numbers have been blacked out, as Eric pointed out. Um, 95 times out of 100, they're going to be fine with it. But Eric raises a really good point that if they don't want that, it's not required by law.
And here's the big issue: expectations. So many times what we do with the purchase agreement is we send it over to our client and say, just sign. And what we see normally is that it was never explained about what happens if there is a dispute with that EMD. What are the expectations of a buyer to understand I'm giving out 5 grand, here you go. Or you get that client who's going to write a check for over $7,000. My point that I'm getting to is that there are risks associated with the amount of EMD. If it's $7,000 or less, any type of dispute could be resolved in a small claims court. If it's over 7,000, you have to hire an attorney and go through the district courts for a dispute. Now, I heard some rumblings that in 2026, that EMD minimum might go from 7,000 to 7,500. So we're waiting still to see. But that might be a conversation you have with your client. If all of a sudden you're putting down 70, $7,200, do you really want to put down $7,200? Because it's a lot easier to go through a small claims court than it is a district and a lot less expensive. So that might be something to at least address with the client about expectations and the amount, as well as just because you terminate lawfully doesn't mean that the seller is going to agree to release your EMD. Anytime someone puts an EMD into a purchase agreement, it is at risk. And we should never be saying to a client, hey, don't worry, you can automatically get your EMD back if you terminate. Let's say I'm going through inspections, 2 days in, we terminate for something because we didn't like something. You should never set up the expectation with your client that they automatically get their EMD. If you're thinking that, it needs to stop. That language needs to be removed. You should always say that your EMD will be at risk, and the only way that we can get it back is if the seller releases it in writing. It's a
I'm
lot
gonna
different practice.
stop for a second here.
Yeah.
Mark Rosas had a question. Mark, do you want to ask your question here for everyone? Where'd he go?
Sorry, Don, I just got off the road. But yeah, I had an instance where I was on the list side and the buyer's agent shared that the earnest money deposit was deposited in cash. At this point, we were close to closing. I never received confirmation that the earnest money was deposited. And because it was cash, the title wasn't able to provide proof for the lender. So we just ended up scratching the EMD, doing an addendum to just remove it from the purchase agreement.
So you're saying that the title company accepted cash for the EMD, which is unusual, rare,
Mm-hmm.
but not illegal. But they had no paper trail to verify that. Is that what you're saying?
Correct. Correct.
Wow.
Yep. So my question was, is that even allowed legally on the title agency's behalf?
Yeah, it's legally allowed. I can't imagine that I mean, it's just sloppy, frankly, that a
Mhm.
title company wouldn't be able to verify those funds, even if they, took a picture of them or something. The dollar bills. I mean, that's just preposterous practices, in my opinion.
Yeah, so
Okay.
to avoid that, don't use cash. Have that paper trail because any title company will want to see, or any lender will want to see where that money came from. And there are going to be more, there's going to be more strict guidelines coming in 2026 from banks starting in the next couple of months about some of these things that we'll be explaining here. But cash and where it's coming from is going to be more looked at in paper trails, and who's buying what and who's selling what will be coming to the forefront of real estate. And we're going to probably be expecting delays in purchases and sellings, but we'll come to that. And what this is really entailing is in Michigan Realtors, they just sent out a recent brochure that came out that uh, The Financial Crimes Enforcement Network, which is FinCEN, will begin March 1st of 2026. This will be the first nationwide permanent reporting rule for residential real estate. So there's going to be a lot more compliance requirements from lenders on who's buying, what they're buying, where the money came from. So this FinCEN, FINCEN, beginning March 1st, is something that's new to the real estate industry for residential. And that was in the Michigan Realtor 2026 Code of Ethics update that just came out. But that's probably something that we'll talk about further as that comes to fruition.
Sadie, you had a question on can an EMD be wired? And the answer is yes, it can. We have to be very careful that we are wiring securely. So that's the only cautionary note. But yeah, we can do that. We can accept a wire.
Sorry, is there a fee for that? And do we reach out to, I guess, our office, Five Star office, or do we reach out to the title company?
Well, it depends on where it's going to be wired. If it's going to be wired to the title company, obviously the title company would have to give you their wiring instructions. Here at Five Star, we would have to have Jeff Bender give you the wiring instructions.
Got it. Do you know if there's a fee for that?
I don't know. I don't.
Thank you.
So let's get back to one final thing about how we communicate about the requirements to get an EMD returned. EMDs are funny because we deal with contract law, and I don't know if anyone listened to Con Ed or if we put you to sleep. If we did, we're very sorry. We tried to do our best with Con Ed and keeping people awake. But there are two types of classes of law that are being reviewed when we deal with EMDs. One is contract law. Other is escrow law. Escrow law supersedes over our purchase agreement language. So any of you out there who practice with this EMD is non-refundable for any reason, or if the buyer terminates for any reason or fails to perform, this EMD is non-refundable. Well, guess what? That doesn't stand according to escrow law. That EMD is not non-refundable. You can't have it released. No matter what you say in your purchase agreement, that EMD money cannot be released unless a buyer and seller write a contract or an acknowledgement about who's going to get the EMD. The only thing that does when someone writes non-refundable EMD is helps you when you go in front of a administrative judge or a magistrate in small claims, or if you hire an attorney, because now the intent of the parties or the meeting of the minds was that this was supposed to be a non-refundable. But even though we said it, the title company or Five Star can't release it because of escrow law. We have to have in writing that it will be returned to one party or the other.
I'm going to add to that non-refundable language has to be very, very clear. It cannot simply say earnest deposit shall be non-refundable. That's not going to hold up in court. There has to be very specific conditions in the purchase agreement which identify exactly the conditions under which that will be non-refundable.
So let me see with a raise of hands. How many of you have been in a situation where your client terminates lawfully under inspections or certain contingencies? Your buyer wants to terminate lawfully. You send over a mutual release with the notion that your EMD will be returned to your buyer, and the seller just looks at this and goes, I'm not signing. Anyone? Michelle? Yeah, yeah. David? Sadie? Yeah. How many others? Kim? Yeah. I think about every single one of us has been in a position where the seller loses their mind and goes, well, I'm just not signing. Does that seller have a right to do so? Yes. Is it frustrating? Yes. should a listing agent probably knock some sense into their client and say, hey, look, they are terminating lawfully. That, I don't see where you have any grounds, but if that's what you decide, then that's what you decide. But just to understand that now we're in a dispute, even though it's unlawful. So the only way to get around it is that your buyer will have to hire an attorney if it's more than $7,000. If it's less than 7,000, they can go to small claims court and go to the county clerk's office and fill out a small claims document. $75 application fee. It might be 95 in certain places. You may have to pay a small amount of money for a subpoena to force the person to come in or to be served the small claims. And understand that uh, there's either two people that will oversee this dispute, an actual judge. If it is a judge, it'll be a final order. If it's a magistrate or administrative judge, and you don't like what they had to say, you can appeal that within 7 days. But if it's a judge that's overseeing that small claims, it's final. If it's a magistrate, then you can appeal it.
I want to be very clear that when we're talking about lawful or unlawful termination, we're not talking about laws on the books like state law or federal law. We're talking about contract law. And what the contract says will determine whether or not that's a lawful or unlawful release or breach of contract. And we can't enforce contracts. That's not our job. That's not within our legal purview. That is only up to a court of law.
Yeah. Now, here's the caveat. It's very easy as agents to tell your clients, well, we have to go to small claims court. If you're going to be recommending that they go to small claims court, please be very careful. You also probably should have a part two on that. Yes, you can go to small claims court, but the other side may hire an attorney and kick this from small claims court up to a district court. Now, your buyer who was thinking that this was going to be very cheap to settle this dispute for 75 bucks, now will have to hire an attorney for $5,000 to $10,000 retainer. And these things don't go away easily, nor are they a high priority for courts. So what ends up happening? Both parties pay $5,000 for an attorney, and then they don't even see the light of day. They end up settling out for whatever money is. And guess who wins? The only person that wins is the attorneys. Isn't that wonderful?
Carrie Mackey has a question. Carrie, could you ask that to the group, please?
Yeah, I was just wondering if you were to put wording into a contract, like sorry, I'm losing my concentration. If you were to put it wording into a contract, if the buyer or seller does not sign a release within so many days or by a certain date, that earnest money automatically gets released to whoever.
Yeah, great question. The answer is no. Doesn't matter what you put in there. You have to have both parties sign off on a written document about who's going to get the EMD.
Yeah, the language in the contract, as Eric says, doesn't matter because contract law is subordinate to escrow law. It's just that simple.
So
Scott
even
St.
if
Pierre?
you clarify in the contract who gets it, if somebody doesn't sign it, I mean, you have it all set, like it's not signed by this date, so and so gets it.
That's
It still
correct.
doesn't matter.
It
Okay.
will strengthen your argument in court that it was very clear, what happens in the event somebody misses a deadline or whatever. But it doesn't give Five Star or the title company the right to release that money based on that language in the contract. Now, you may find some title companies or brokers who will take that risk and say, hey, it's right in the contract. We'll fight that battle later. I think it's a dangerous thing to do. Blake, you have a question.
Well, we've had discussions in the last year or so about even using EMDs anymore. Has anybody ever written last year without an EMD? And how, if they have done that, how did it go? Or is this just going to be a requirement? Do people expect to have a deposit made on a purchase
Yeah,
contract?
there's no legal requirement to have it, but I have personally not seen many offers that don't have it. In fact, I can't recall any recently. I think that sellers still believe they want to see some skin in the game on the part of the buyer.
Yeah, we usually see anywhere from 1 to 3% of the sales price for an EMD. Uh, I try to get away with the smallest amount of EMD that I can. If I had it my way, I wish associations would just strike that right out because all it turns into is a point of contention. You have unreasonable sellers and buyers who cannot agree. There's a lot of contingencies in a purchase agreement where someone can get out legally and lawfully, yet a seller ends up being annoyed because, well, they have entitlement issues. And sometimes I have to wonder if that's just our own industry puffing up their client and telling them something where they all of a sudden feel entitled instead of just explaining, hey, look, it's in your best interest that uh, we just return this. But here's the thing. Here's what the problem is. There is no penalty for the seller for being a jerk and not releasing it. That's the problem. So they get a free pass for being the idiots that they are uh, when a buyer lawfully terminates because they don't have to do anything. They don't care. I've heard this so many times, well, it can just sit there for all I care. It's not my problem. And they're right. I mean, it doesn't turn to be the problem. It ends up being the buyer's problem having to recollect this, which I've always said, then why am I paying a large EMD?
Yeah. Sadie, I want to have you ask the group the question because it's a great question. And then we probably should move on to the walkthroughs and so on. Eric.
Yes, my question is just wanted clarification on the part where you said that the EMD is not legally required. My question is, isn't it though, since it's written in the PA in the purchase agreement that is needed within 72 hours, will that make it legally required?
It's not legally required by state law. But if it is mentioned in the contract and there's an agreement on the part of the buyer to pay an EMD, then you're absolutely right. Yes, it would be a contractual obligation.
Don and Eric, I have a quick question.
Yeah, good.
So far, we've been talking about the sellers and their performance about releasing EMDs. Working as a listing agent, what do you recommend I do or listing agents do when the buyer doesn't perform and the buyer's agent doesn't see the significance of having the EMD deposited within the 72 hours as it states in the WIMLAR purchase agreement? The only thing I see right now is the seller may terminate, but if you have a good contract and you want to keep the deal moving and the buyer agent isn't performing, what can you do?
The first thing I would do is I would draft an addendum extending the timelines within that and specifying that we're going to extend the timeline for the buyer to deposit the EMD from 72 hours until a specific date and time with the language in there that if they don't perform, the seller hereby terminates.
Yeah, I think that's great. Carrie has another comment on that. And she says if it's written to the contract and isn't received or a bad check, does that make the contract void? And I'm going to turn to Eric because there's a difference between void and voidable. And Eric, correct me if I'm wrong, but this would be make it a voidable contract. Is that correct?
Correct. Avoidable is a one-sided termination. So yes, a buyer didn't perform. They didn't secure their EMD to a broker or title. And some of the language right in there states that there is a consequence that if this EMD is not turned in or that they fail to do so, the seller can terminate under this provision. So there is already language drafted in a lot of the EMD language within your purchase agreement when a buyer doesn't perform.
It doesn't make the contract automatically null and void, but the other party, the seller could terminate based on the buyer's lack of performance.
And that EMD then was supposed to be there for liquidated damages. So even though it
JT,
wasn't collected, if it wasn't collected, uh, this is where a seller would go in small claims, and the judge would probably look at that and award that EMD that was supposed to be collected and deposited to a seller for liquidated damages. So ultimately,
Let's talk
again,
about
timing is an
final.
issue when it comes to
Do you know what
EMDs.
I would need to be able to do Zooms in here?
All right, Don,
I have a quick question. Do you mind if I
no,
ask?
go ahead.
So I'm thinking about that addendum that would give the seller, they define if the EMD hasn't been turned in a certain amount of time, they give a deadline. But the addendum, so they write it, they draft it, the seller drafts it, that's their intent. But the buyer, if they don't sign it and accept that, then it's not part of the agreement. So then can they act on it?
Well, I would say that if the buyer isn't going to assign that addendum to extend that deadline, then the seller just would terminate. They'd have every right that you could cite a breach of contract that the buyer failed to perform, submitting an EMD according to the purchase agreement. Therefore, seller hereby terminates the purchase agreement.
Do we have any more questions on EMDs? Because Eric, we got some great information that we want to get to, and there's 20 minutes left here. So,
Go ahead, Don. I'll let you jump in here.
well, let's talk about. Thanks, Eric. Nice one. Um, what about final walkthroughs? How many of you have put in your contract that you're going to have a final walkthrough? I would hope everyone does. What
Hey,
happens?
Don.
Yes,
I,
sir.
I think that the final walkthrough is next week.
Oh, I'm sorry. I was reading the wrong outline. I apologize. So Eric has more on the EMDs, I guess.
No, we're just wrapping up here, but
Oh,
I wanted to open up to questions and whatnot. Uh, but I wanted to emphasize a couple things real quick here that with the EMD, it's really, it just shows the seller that the buyer is serious and has skin in the game. That's really what an EMD is showing. And historically, EMDs were show that the higher the EMD, the stronger the buyer. That's typically what we've seen in industry, that they are serious and they do want to commit to this process. And when we see a buyer and seller go through a dispute or a buyer terminates unlawfully or they terminate not under a contingency, but they just get cold feet or something, typically what we will see is that EMD will be used to compensate the seller for removing the home from the market and potentially missing other offers. That's the intent of these EMDs. And that EMD it would also be used typically to support the seller for liquidated damages if that buyer ended up terminating unlawfully, such as I got cold feet. Now, here's the big thing, and I can't stress this enough. Do not ever tell the other side why your client is terminating. If they're going to terminate, just specify they're terminating according to whatever section. Cite the section within your purchase agreement because we can't screw that up because we're stating we're terminating doing inspections. We don't have any duty to tell them why we're terminating if we're terminating, and it's a lawful termination within one of the contingencies that we're facing. Too many times we open up Pandora's box and we say, well, just want to let you know my client's terminating. We're going to be sending something over. Well, and then they say, well, my client changed their mind. Boom. Uh, you may have just broken fiduciary responsibilities, and you're going to put yourself into a potential lawsuit because the listing agent will say, well, you're not terminating due to inspections. You just told me they're terminating because they have cold feet. Well, maybe they had warm feet. I just misphrased it. I don't know. So be careful about what you say. Don, you're on mute. I'm gonna go and unmute.
You can't reel that back in either. You can't say, oh, well, no, we're gonna go do inspections now and have your Uncle Charlie, who likes to spend a little bit of time down at the tavern, go and do an inspection. That train has left the station. Once you disclose to the listing agent that your buyer is terminating for reasons other than are stated in the contract, like inspections, for example.
And keep in mind that that EMD is going to be credited back to your buyer as a down payment or for closing costs if you get to the closing. So that helps. And this is another reason why the banks need to know where that money came from.
Ruth Ann, the answer is no. You do not have to say buyers terminating based on inspections. Um, does it happen? Is it common practice? Sure. Yeah, it happens. And I don't think there's anything horribly wrong with that. But I think if it helps facilitate the buyer getting their money back, that's probably not a bad thing. But be very, very careful that we never uh, disclose something that is not pertinent to the contract, like they got cold feet or their promotion that they thought they were going to get isn't going to go through, or gee, they had a big fight over the weekend, they broke up, now they're going to get a divorce. No, none of that should be disclosed to the listing agent.
Any other questions? If you want, you can unmute or you can put it in the chat.
I just put it in the chat, but in the previous case, in the case they do change their mind and they haven't gone through inspections yet, and they still within the inspection period, what do you suggest would you would just send in a release of mutual release without any reasons, or how do you handle that?
Well, it's a good question, Sadie, and it depends on the contract that you're using. Some of our contracts require that an inspection be performed by a professional inspector or some type of service like that. Many of them do not. The West Michigan Regional Purchase Agreement allows anyone to do an inspection. So if your buyer says, well, I think we want to terminate, we don't want to pay for inspections, we've had second thoughts, then I would encourage the buyer to have some sort of inspection performed so that they are terminating within the terms of the contract, even if it's their uncle doing an inspection.
And when in doubt, what would the attorney say? Well, if your client really needs help, we should always be asking, well, you may want to consider talking to an attorney anytime someone terminates. But if they're going to terminate lawfully within a contingency, then I would probably just move forward with whatever that contingency is, perform according to the contingency, and then terminate appropriately.
Okay, I don't know who's asking the question here. So if selling agent asks why, or can you tell me what was wrong with the inspection? I think you use your best judgment. Could you tell them that it was based on inspections? Absolutely. If that in fact is the case, I think that it's dangerous. Again, you can't go down the road of anything that is not in connection or concert with the contract. When you do that, you're putting your client at risk.
Question here is I'm a little confused. Can you terminate a contract with no reason? You can, but uh, I would try to terminate within a contingency that allows and grants you the power to terminate lawfully, such as inspections, well and
Yeah,
septic, if
yeah,
it allowed.
I would be very cautious about terminating with no reason, obviously. It has to be a termination within the terms of the contract.
Another,
Now, and also keep in mind, it also depends on the location where you're practicing real estate and the purchase agreement language. Some locations require the buyer to send over a repair addendum. It doesn't grant the buyer the automatic right to terminate based on inspections. It requires a buyer's agent to draft a repair addendum to the seller, which then gives the seller the right to either terminate or renegotiate or do nothing with that repair request. So, in certain situations like that, a buyer may say and be very egregious that, hey, I want a new roof based on the repairs. Well, the roof's 2 years old. Don't care. Want a new roof. Seller would get that and say, wow, this guy's a real doozy. Uh, we're not going to agree to a new roof. We're terminating. Or they may
Well,
do
let me
nothing,
let
which
me
would then go back to the buyer to have 5 days to either terminate or move forward with the home as is.
again, this goes back to what is your purchase agreement that you're using in your market say? Historically, over the last 15, 20 years, in Grand Rapids, the West Michigan Regional Purchase Agreement allowed a seller to terminate an offer if a buyer, based on inspection, sent over a request for concessions or repairs. The seller could flat out terminate the offer. That practice is going away. And we don't have the forms are being changed right now. And we're going to see that our practice in the greater Grand Rapids area is going to be more reflective of what happens in GCAR and Lansing and up north. There are changes going on. They are no longer kicking a buyer to the curb based on their request to have inspections, or I mean, based on inspections. Carla had a question. I'm going to go back to that just for a second. If you terminate after the final walkthrough, can you get the EMD back? Contractually, it would say that you can, but as we've mentioned several times, the contract is subordinate to escrow law. And there is, you just said that you did it because there was water underwater or whatever, and that may be legitimate. The problem is that the contract law is subordinate to escrow law, and we have to follow escrow law first. So you got to get a mutual release, have both parties sign it, or go to court. That's the bottom line.
And another option that someone could use, or another tactic, if you found that there was water before closing, well, of course you wouldn't want to close, but what would the seller have to now do or disclose because there's a water problem? That's right, a seller's disclosure would have to be updated. So now, once you have a new seller's disclosure, the buyer now has 72 hours to review that. They can accept it or terminate lawfully.
But Eric, I want to bring since we're going in that direction just for a moment, I want to bring that up. Once you find out that there is a material defect, if you will, such as the water in the basement prior to when the buyer goes through and does a walkthrough, if you're the listing agent, do you have a responsibility to disclose that to a buyer if in fact that is verifiable information?
Yes. Absolutely, without question. Yep.
Yep. Yep. By law, you have to disclose if it's a matter of opinion, that's something else again. But if you have legitimate, verifiable information, and I think that's kind of what Leslie may have been hinting at in her comment is, sometimes I just don't want to know. I don't want to know if your buyer thinks that the little crack in the corner window is a material defect. I don't I don't necessarily need or want to know that. But if I come to know that and it's material fact being any information that a buyer may get that could change their mind, that's kind of a broad measure. So if you get that, then you have a responsibility to share it with other potential buyers.
And Don, finish your thought there. Then the buyer gets to review that. They have a period of what, 72 hours to review that and decide either way whether or not they're going to go forward and close or not, or terminate, correct?
You're talking about like if they put forth an inspection request for concessions or whatever?
Well, if they change, if that seller, if that the water in the basement, we're using that as the example, that comes up 3 days before closing. The seller does what they're supposed to do, which is to update the seller's disclosure statement, share that information then with the buyer. The buyer then has that period of time, and I think you mentioned 72 hours, right?
Actually, I believe, Eric, and correct me if I'm wrong, but I think Patrick, you said there's no time limit. If it comes up after the 72 hours of the seller's disclosure,
Mhm.
it's a material defect. There's no time limit. The buyer could.
And then buyers could terminate no matter what. Okay.
Yeah, the
Okay.
material defect is the caveat here. All of a sudden, a material defect, something that wasn't there, water in the basement's a big one. That buyer now has the right to terminate basically whenever.
Got it.
But I would recommend sooner than later.
Absolutely.
Don't screw around with it.
Yep.
And then you would still have to, the seller would still then provide a new seller's disclosure, which we've always said 72 hours because that's what's referenced within that document.
Yep. I agree. All right. Good. Thanks.
Well, I want to thank everyone for joining us. There's nothing further on the EMD that we have to share, but you can always give us a call, 616 the 490-0902 for broker support. Or in Florida, you can always call us the broker support line, and either broker support or the deal doctors can help answer any additional questions directly with you one-on-one. In case you were a little shy today and you didn't want to reach out to all of us in the group, we're here for you.
Thank you all for joining.
Thank
Yes,
you.
have a
Thanks,
great week.
Eric. Thanks, Don.